Hello everybody, welcome to the second lecture of the International Business Law course. We start again with a nice picture of very recent days in which you came to university, happy to meet and interact with other people. But as said in the previous lecture, it is all online now, so we're also going to do the second lecture of today, which is, let me see if it works. Yes, it works. The second lecture of week 1 is going to be recorded now. So let's make a start and let's first look at the learning objectives and see where it links. Because today we are going to focus on the second part of bridging theory and practice. We're going to look into application, and what we're going to apply roughly is the structure we learned in chapter 1. And the structure we're going to apply on something, and that something is the Netherlands. Now I say the Netherlands, but when I say the Netherlands I speak about a country. That is a political perspective on a piece of ground which has borders and which is recognized as being a country. When we look at it from a business perspective, and you know we link legal and business perspective, at least we try to do so continuously. If we look at it from a business perspective, we see a market which contains consumers with purchasing power, which are, if you can persuade them, willing to give money for your products. If we look at it from a legal perspective, we see a jurisdiction and the state. The jurisdiction means that there is a territory in which a set of legislation and other types of rules are effective. Why? Because countries are sovereign, they make their own rules, and they make the rules within their borders, which from a legal perspective is the jurisdiction. Now, if you remember well, we introduced in the first chapter a structure, an analysis structure. Why did we introduce it? We introduced it because we look at the world from the perspective of strategic management. And you know that in strategic management, analyses, always difficult to pronounce the plural, analyses are the basis for strategies, for what the company decides to do on markets. And we said in lecture 1 that we analyze an internal and analyze an external environment. Today the focus is on the Netherlands. That's the country, the market, the jurisdiction we're going to analyze. And we use this structure, the structure you see now of the 6 S's. Those were introduced in chapter 1. Those we are going to apply roughly to give you an indication of what to look at when you are in the situation that you should analyze a market in which your company is already operating, or a market which your company plans to enter. The structure will allow you to quickly draw up a picture, and that information will be helpful to you in developing strategies. Ultimately, the internal and the external analysis provide what we very fashionably call strategic input. Now you see this structure reflected in chapters 2's index. Here we go and start with a slight introduction. Then we go to the 6 S's: specific, soft law, self-regulation, supervision, solutions, and services providers. We'll illustrate these categories of research of a market with examples. And then we're going to look into a specific area of law, which usually is of great interest for companies because it involves resources, the people you employ, and it involves potential costs when you want to restructure or terminate employment contracts, you run into cost. Now, why do we look at it specifically when we are looking at the Netherlands? For the reason that employment and social security laws in the Netherlands are horribly complicated. Yet the aim we have with it in introducing it to you is to show you how a legal system can work, and also to make you aware of the fact what are the elements to look at when you would be in the position of having to make decisions which relate to employment. And they can of course relate to recruitment, but they can also relate to specifically termination. So that is for the end. First we go to the analysis part and we play the game again. The game that you are managing an EMEA territory, 116 countries, and one of them is the Netherlands. Now, you should be aware now that the Netherlands has a regulatory environment. But the complication we immediately introduce now, but which we will look at in the next lecture, is the European Union. So when you analyze the Netherlands, you basically have two regulatory environments to analyze. You have the country, the Netherlands, and you have the EU, which, as we will see in lecture 3, is also able to create rules which can affect companies. Now, before we go into the details of the analysis, we'll start off with some general information. And this general information is to illustrate to you how complicated a country can be. If we take, for example, the Netherlands, we start off with two parts. We are a kingdom. You will all know we have a king. But we also have the Netherlands. Now, the kingdom is composed of, and it's rather complicated, 3 overseas countries. The countries are Aruba, Curacao, and Sint Maarten. They all have their own flag. And in the same Caribbean area, you have 3 special municipalities. 3 other islands, Bonaire, Saba, and Sint Eustatius, who are part of the kingdom, but are not in the Netherlands. The Netherlands is the territory in Europe, but they are part of the kingdom. Now we go to the left-hand side, and a state is, from a business perspective, a market. Now, the state is structured in a certain manner, and the structure of the state influences what the market is. We are focusing on regulation. Now, if we look at the state from a law perspective, the question is, at which level are rules created? Is it at one level or is it at more levels? Why is that interesting from a business perspective? Because businesses analyze environments. We are making here a plea to analyze the regulatory environment. Now, if the regulatory environment is analyzed in a federal state, like the USA, you have different layers of regulation. The US is a federal state, which result in certain parts of regulation being exclusively regulated at federal level, but most parts of the law, most parts of regulations are created at state level. So when you analyze the US, pending what you're looking for, you analyze developments at federal level and developments in the states in which you're doing business. The Netherlands is in that sense, but not in many other senses, is in that sense simple. In the sense that it is a unitary state, it is not a federation, it is one country with one national level of regulation. Now, when we look at a state from a legal perspective, we immediately think about a theory about how to organize a state. And that theory is the theory of the trias politica. centuries ago developed by a French philosopher called Montesquieu. And Montesquieu said, if you want to organize a state, you need three powers. You need an executive, a government, you need a legislator who makes laws, and you need a judiciary, a system of courts and judges who apply the law. Now that is interesting from a business perspective, specifically, of course, the legislator. We, from a business perspective, would like to know how rules are made and by which bodies or by which body those rules are made, because ultimately we are interested in influencing regulatory processes. And you can only influence a process if you know the process. Now, what is the basic document which defines a state's organization? Generally, it is a constitution. We, the Netherlands, have a constitution, and in the constitution you'll find outlined, described, the role of the king, how the constitution is changed, but specifically of importance to us is who is the legislator, who is the executive, and what can we read in the constitution about courts. One reason is that we are interested in where the rules are made. The other reason is that we are interested in the judiciary because we like to do business in reliable environments, and in this context we mean with reliable environments a court system which is independent. If the courts are not independent, going to court is of, or can be, of little use for a company. So we would like to have a state, if we do business in that state, which has a constitution, and that constitution safeguards a proper organization of the state in such a way that it creates an environment in which business is predictable. Now, as said, the Netherlands is rather complicated. This is translated into a constitution for the Netherlands, the territory in Europe, and a statute which is like a constitution, but that is for the whole kingdom. If we go to the bottom bullet points, as said, the whole kingdom has 4 countries. The Netherlands is an EU member, but the EU also regulates overseas countries and territories. Here you can go to the websites. In principle, the overseas countries and territories are not an EU member, but can profit from the freedom of movement. So people who live on these islands can freely move into the European Union, and there are also special provisions for export from the overseas countries and territories into the EU. But the whole issue is extremely complicated, so we'll leave it to this level. Then the Netherlands has another peculiar feature, and that is that we have historical ties with Belgium and Luxembourg. And that has led to the creation of an organization which is called the Benelux. And that Benelux organization has created legislation which is common, which is shared by all the 3 Benelux members. Specifically, intellectual property law, we will look into that in chapter 5, is regulated for a part at Benelux level. And then the Netherlands, we are an open international economy, and from that perspective, Dutch governments have always been keen on entering into all kinds of international treaties, and we are a signature to many treaties. We have so-called bilateral investment treaties, and those bilateral investment treaties with other countries often include a clause, and that clause is abbreviated here as ISDS, which means Investor State Dispute Settlement Clause. It is a clause by which governments of the countries which participate in a treaty promise that if they take measures which turn out to be harmful for the investment made by a company from another country which has signed the treaty, that the company which is harmed is under certain circumstances able to claim compensation from the government. Keep that in mind when we talk about Dutch letterbox companies. Then we have a lot of double taxation treaties, which means that two countries agree that if tax is levied in one country, the same tax will not again be levied in the other country. Keep that in mind when we talk about Dutch letterbox companies. Then we are a member of important international treaties, which are sometimes referred to as conventions, and this CISG is the abbreviation for the Convention on the International Sale of Goods. That will be discussed when we look into international commercial contracts in chapter 8. Now if we move on, we can have a break, but I'll leave the break to you. If you go to the PowerPoint set of slides, you will find this slide. You can click here, and if you click here you get a video which explains to you the incredibly complicated structure of an at first sight simple country like the Netherlands. Have a look at the video and be amazed. We are doing a general introduction, so just a few more words in this general introduction context. We are an international country with an open economy. 60–70% of our income is generated abroad by investments and by exports, and the top three industries are agriculture, energy and chemicals. In the first lecture we introduced some reports to you, and we said when you are in business, I hope you become convinced of the fact that you must analyze regulatory environments, but there's always a bit of overlap with the business environment. Business and law are rather close with each other. One of the reports which was introduced was a report from the World Bank. They annually publish reports about the ease of doing business, and here are the scores for the Netherlands. Now, just to illustrate to you some good points and at least one minor point. Some good points are that it is relatively easy to start a business in the Netherlands. That's of course positive in these days of tech startups and you young people dreaming about starting your own company. Paying taxes is also not too complicated, although we've heard horrible stories about normal people and their conflicts with the tax authorities, but for businesses in general it seems to be not too complicated. And then we have a minor point, and that minor point relates directly to law. Enforcing contracts, so you have a contract with another company, they don't pay you, you want to get the money, you go to court, it takes some days, it takes some cost. But in that respect, and we will see that later in chapter 6, the score of the Netherlands is not that positive. But what are we really good at? What is our strong point? We are number one in trading across barriers. What does that mean? It means that the country has an infrastructure and the knowledge for international business. And that means that the Netherlands is, if you would base it only on this, a fairly ideal place to start an international business or to start a local business and to grow international. Now, those are some of the scores which are made by the World Bank for 190 countries in the world, and they can quickly tell you something about the complexity of starting a business in another country. It's quite valuable information, I would say. But there's a lot going on in the world, and the Dutch have a tendency to be a bit sneaky. We are small, so we have to be clever. And silently, we are, of course, luring, difficult English word, luring British companies or companies established in the UK to come to the Netherlands because Brexit is coming. At the moment, it looks that it might be a hard Brexit, but let's wait and see what really happens. But we have already convinced 100 companies from the UK to move their business to the Netherlands. If you think back of the previous scores from the Doing Business in the Netherlands report, you can understand why the Dutch can give good reasons to companies in the UK to come to the Netherlands. One of the main reasons, of course, being that we are still in the European Union, which, as we will see in the next lecture, has many advantages for companies. Now, in general, the people come here because we have a good operating structure. We are in the European Union. There's a lot of people here who speak English. I'll leave it up to the British people to decide whether that English is good or not. But don't take our Prime Minister as being representative for the pronunciation of English. But in general, people can speak it fairly well. So this creates a picture of a country which has a lot to offer to international companies. Well, that is nice for you when you are studying international business. Now let's go on and let's run through the 6 S's. So you know, in chapter 1 and just a few slides ago, we introduced this 6 S's model. That's what we're going to run through, and then when we're finished with it, we'll look into employment law and social security. When we start the analysis, we have the S of specific. Well, you know that hard law, what stands here, represents legislation, the binding rules created by, remember the trias politica, a legislator. Now, which part of the total of law, which is an incredible volume of course, which part of the total of law is of specific interest to your company? That is of course something to be decided by your company. You need some basic knowledge of the areas of law, link that to your business, and then decide for yourself which part of the hard law should we devote interest to in order to see whether there are developments which may affect our company. A starting point in your analysis of hard law of a country is the notion, is it a civil law or is it a common law country? When it is a common law country, you know that you should not only look into potential new legislation, developments in legislation, but that you should also focus on court decisions, because you know that in common law countries the judges play a central role in creating rules. When it is a common law country, the focus is more on legislation, but knowing that judges apply the legislation, it may well be so that interesting court cases may lead to decisions which have a relevance for your business. So the starting point is a bit different. In the end, I think for both legal traditions you should analyze developments in legislation, developments in case law, and basically the same applies to Islamic law countries where you have courts, where you have legislation, and where you have religious scholars who interpret the rules of the Sharia and who advise companies on how to apply the Sharia on their new products or new services. So if we go back to the Netherlands, and we know now that it is a civil law country, it is nice, I think, to illustrate that our legal system was imposed upon us by Napoleon. Napoleon was, in many respects, a genius, and Napoleon had the brilliant idea: if I create law books, I can introduce the law books in all the countries which I conquer, and in that way I unify them. I create my own global empire. So the law books which Napoleon ordered, a civil law book, a criminal law book, a commercial law book, they all were imposed on the Dutch when they were conquered by the French. So we were a French province once. And after we were liberated in 1815, it took till 1838 to have the French law translated into Dutch. So the civil code we have has resemblances in many respects with the French civil code, because the starting point for French law and Dutch law is the same, the legal system as developed by Napoleon. In business, right, here we have an outline of the legislative process of the Netherlands. What you see in the left-hand top box is the right of initiative. This is the right which generally the Constitution assigns to a body of the state. In the Netherlands, the right of initiative is in the hands of both the government and members of parliament. That is basically against the idea of the trias politica, because the trias politica idea is that authorities of the state are threefold and they must be independent. But what we see here is that the government, which is the executive, also has the right of initiative. And the parliament also has it. So because the government as executive also has the right of initiative, executive and legislative powers overlap. So in the Netherlands, the system of the tria politica is not implemented in the structure of the state perfectly. Now, the government, MPs, when they have a legislative proposal, they will put the proposal in the open. They will make it available to the public in an internet consultation. The next slide shows you an example. After that and potential amendments, the draft goes to the Council of State for advice. The Council of State always advises on any possible new piece of legislation. It will then be discussed in our second chamber, which is the Parliament or House of Representatives. Amendments may be made, and then ultimately or not, the legislative proposal is adopted. It then goes to the first chamber, where it is discussed and adopted or rejected. It will not be amended there, that is not possible. Then when it is adopted, the king will sign and the minister involved will countersign. That is followed by the signature of the Minister of Justice. Then it is published in the Staatscourant, that's the official bulletin of the government, which is now published in PDF format and no longer in print. In the publication will be stated when the law becomes effective, but there are pieces of legislation which contain elements which need to be changed from time to time. Think, for example, of an interest percentage. Interest tends to fluctuate, and when an interest percentage in a law would have to be changed by going through this whole process, that would make it impossible to adapt legislation, rules, timely to changes in society. So sometimes the law will allow, the new law will allow elements to be changed by the government, by what we call an order in council, or by a minister in what we call a ministerial regulation. Here you see an example of this internet consultation by the Dutch government. Keep in mind that if something is published which is of relevance to a company or more companies, that they will consult with their industry association, or if they're really big, with their law firm, and they will submit comments, and they will try to have those comments resulting in changes which are beneficial to them, or that the comments are documented in the history of the law, the history which describes the path from draft to legislation, and companies then create for themselves the opportunity that if necessary in the future, they can rely on something they submitted and which is included in the memorandum, the whole description of the history of the legislation and all the changes which took place. Now, law is voluminous, so you may see law students walking around at university. Yeah, in the past, not now, because we're not allowed to go there. But law students usually have to carry big books full of legislation. And here you have an example of just a bundle of private law, Dutch private law. And why private law? Because that has the main interest from our business perspective. Because from a business perspective, we try to make money. And making money is for the bigger part done by contracts. And contracts are typical private law regulated issues. It is private law that describes how we can make contracts and how we can terminate contracts and what we can ask for when somebody does not meet his contractual obligations. And where do we find all that? We find that in a set of books. We are a civil law country, and this civil law country has a civil code. And here you see the structure of the Dutch civil code. The civil code consists of books, and all these books regulate a specific topic. When we talk about marriage and children, we find it in Book 1, Persons and Family Law. When we look at companies which operate independently in society, we talk about legal persons. Those rules are in Book 2. And then we have Book 3, we'll come to that later, that regulates patrimonial law, and that comes down to the rules for property and the rules for contracts. But if you look at this list, you don't see the word contract. No, that's true. We don't have a contract law, but we have an area of law, a branch of law, which we call the law of obligations. Obligations from contracts and obligations which come from the law. And now we come to a point in which civil law differs from common law. And that point is the so-called open norms. Napoleon had the idea that legal rules should be written in a bit of a general way, because if they are not too detailed, they give judges the opportunity to complete the rule in a way that best fits the circumstances. So it resulted in law books, a civil code, which contains articles, rules, but the articles often contain words which we call open norms. For example, what does timely mean? What is fair? What is adequate? What is without delay? They are all open norms. They don't have a fixed meaning, but the judge will, in the circumstances, complete the open norm. Now, these open norms are a thing which is not preferred under common law. Common law prefers parties to regulate their relationship as explicitly and clearly as possible by themselves in contracts. But Dutch law contains a lot of so-called supplementary law, and Dutch contracts do not need to regulate everything because there are law books, and in these law books are rules, and those rules are supplementary, meaning that if the parties did not regulate it in their contracts, the law will give a rule. But as these rules are formulated rather openly, it is not always very well predictable what the outcome of a court case will be. It is not always completely predictable how a judge will complete an open norm in the specific circumstances. Well, that is a difference between common law and civil law, and it is one of the reasons why in international business common law is generally preferred over civil law. More about that in the rest of the course. What you are also interested in from a hard law perspective is taxes. When you study finance, you will study costs. I think you will also look into corporate tax, because corporate tax is what you need to pay on your profit to the government. And of course, tax systems will also allow certain costs to be deducted from the profit. So you're interested in tax law from two perspectives. Which cost can I deduct to reduce my ultimate corporate tax rate? And what is the tax rate? Now, in the Netherlands, the system is as follows. You have a threshold of 200,000 euro profit. At the moment, the corporate tax rate for these up to those 200,000 euro profit is 16.5% corporate tax. And when you go over the 200,000, it is subject to a 25% tax. That is the system in the Netherlands. This is only part of the picture, of course, because what is also relevant is what is tax deductible, and what is also relevant is what other tax facilities does a country offer. And in that respect, the Netherlands has a lot to offer, because in our regulatory environment, the opportunity is available to create a letterbox company. Well, that I think is possible in any country in the world, to create a company which is a letterbox company. But Dutch letterbox companies are created because the Dutch tax system offers fantastic opportunities to companies. The Netherlands is criticized internationally for its system of letterbox companies. Over the years, Dutch governments have said that they would do something about our tax system, which would make it less harmful for other countries. But over the years, not too much has been done. The strategy of the government was always to lift it to a European level and saying, yeah, that is something we should regulate at an EU level. We cannot do that at a national level, so they postpone it a bit. The criticism was growing, and gradually something is done about it. Gradually, the opportunities for letterbox companies to avoid paying taxes in other countries have been limited. Now, what is the beauty of the Netherlands? If you have a letterbox company, you can send an invoice to your own company in another country. For example, your letterbox company holds a trademark. You allow your subsidiary in Japan to use that trademark, so you make a contract, And for using their trademark, they pay you an amount of money. So you send the bill to Japan. Japan pays the money to your Dutch letterbox company. The profit in Japan is reduced. Now, I don't know by heart what the corporate tax rate in Japan is, but it will also be something like 20-25%. So that is saved. Yeah, the profit in Japan is reduced. Then the money comes to the Netherlands. It is booked as royalties, money which is being paid for the use of an IP right, and it is hardly taxed in the Netherlands. Then you can send it to any tax haven anywhere in the world with which the Netherlands has a double taxation treaty, or where corporate tax is not levied, and then it is either already taxed here, so it will not be taxed again, or you send it to a tax haven where there is no corporate tax, and you collect there on the Bermuda or Cayman Islands or wherever all the money from all your subsidiaries in the world. So the letterbox company sends out invoices to your subsidiaries all across the world. The money is pooled in the Netherlands, hardly taxed, and then sent to a third country. Don't think it's only done by companies. It's also done by artists like U2 and the Rolling Stones, who have letterbox companies here in Amsterdam, for the simple reason that they reduce their total tax rate for all the revenues they generate all across the world. Now we go on, and we're going to have a look at soft law. Let me have a sip of my coffee. Soft law is usually a bit of a difficult concept to understand, because the first notion is that we call it law, but it is not binding. So soft and law is a bit of a strange combination, because soft law is actually not law, but it is considered to be something quite close to law by specifically international companies. The best way to illustrate this is to give you an example. Soft law is something which comes from, simply said, important organizations. Now, needless to say that the United Nations is an important organization. The United Nations, and more specifically a former president of the United Nations, who came from Ghana, Kofi Annan, took the initiative to try and create something which would make international business more fair and which would stimulate international companies to contribute to a better world. That initiative is the Global Compact Initiative. And the Global Compact Initiative is based on 10 principles. You can see the principles here. And the United Nations asks companies to implement these 10 principles. It asks them to create a system, a process in their company by which they ensure that the business they do wherever in the world is within the setting of these 10 principles. They should commit themselves to it, assess to what extent they comply, then define how they're going to improve their compliance, implement it, measure whether they reach their goals, and then communicate it to the outside world. Now, to illustrate to you how important soft law is, in the Netherlands we have 184 companies, they are the bigger multinational companies, who have declared their commitment to implementing the Global Compact. And one of them is the food company Unilever. And Unilever yearly communicates on their progress. So they report to the world, specifically of course to their stakeholders, to what extent and how they have implemented the 10 principles of the Global Compact Initiative. Back to the beginning, soft law is not binding, but because it comes from reputable, important international organizations, specifically international companies are strongly inclined to implement soft law. Unilever reports on it extensively in a self-assessment report, and if you want to read more about it, everything in the slides is clickable, so you can go to the original source to read more about it. The next S of the 6 S's is the S of self-regulation. And why is self-regulation so emphasized in this course? That is that the importance of self-regulation in business is big. We will see when we look into advertising that in most countries of the world there are codes of practice which regulate advertising. We will see that industry organizations have created playing fields for their members by defining rules to which all members of the industry organization should voluntarily adhere. We will see that companies have created internally self-regulation in the form of code of conduct. Code of conduct for which you, when you start working for a company, have to sign that you will comply to the code of conduct. And if you don't do, you may face a very serious employment law problem. So this self-regulation is important. Two examples. First of all, you will find self-regulation in specifically industries which are subject to criticism, who have an interest in ensuring a good image, a good corporate image, and one of them is, of course, the pharmaceutical industry. For years and years, the pharmaceutical industry was constantly criticized. Now we are in the situation that the world needs them, because to whom is the world relying for a vaccine? Yes, the industry. With whom are governments now cooperating and promising hundreds of millions of dollars for vaccines? The pharmaceutical industry. Now, the pharmaceutical industry has always put much emphasis on trying to operate in a responsible manner, and what you see here is self-regulation for pharmaceutical advertising. It is all kinds of rules developed by the pharmaceutical industry itself, to which it voluntarily submits itself and which is implemented by their own committee. And with that committee, any company can file a complaint, or any individual can file a complaint about a company which, in their eyes, does not adhere to the code which regulates, in this case, pharmaceutical advertising. Now, Unilever has it for itself, their code of business principles, an extensive list of rules, all self-regulation, by which it defines how it does its business. Briefly introduced in the first chapter, and one of the services providers with which you will cooperate within a company setting, so within the company, are in-house counsels, the lawyers, the corporate lawyers who are employed by a company. And when you work for a company, they will be your colleagues with whom you need to cooperate. You will have to see them when you run into a legal question, but as a doctor needs to, as a doctor needs to study anatomy in order to understand the human body, you are required to study law in order to understand the body of law and in order to sense, when you're working in a company, where you could run into legal problems. Now, we just looked into the code of business principles of Unilever, and in that code you will even find explicitly defined how you should behave with respect to consulting legal on questions you have. So Unilever has in its code of conduct documented all kinds of initiatives and paths and policies you will have to follow when you work for them. And in your employment contract you will sign for compliance to all this. And Unilever has even documented how you as an employee should deal with consulting your legal colleagues. Now, so we've seen self-regulation now in a company, in an industry, the pharmaceutical industry, and we move on to the next S, and the next S is the S of supervision. You as a company are operating in a market, in a country. The legal system may contain supervisory authorities. Generally, you will find them in all developed countries that are bodies which are created by the legislator, which specifically look at specific industries and assess whether those industries are compliant with the rules which apply to them, and if not, they have certain authorities, they have the possibility to impose a penalty on a company. Now, you for yourself, when you operate in a market, must assess, are we subject to a specific supervisory authority, and how active are they? In other words, what is the risk that they will look into my business, and what could then be the potential consequence in terms of penalties, and specifically, of course, in terms of financial penalties. Because in the first chapter we had this list of legal risks and we just briefly run through it, but here you see the word prosecution. Prosecution means that the state takes action and prosecutes you for your behavior in order to impose a penalty upon you. Now, that is typically done when we talk about business. The next element of the regulatory environment to be analyzed from a business perspective is the S of solutions. We already said in the beginning, we want a reliable court system in our markets, because we must have the certainty that if somebody violates a patent of us or another intellectual property right or does not pay, that we can get the money by going to court. So the market, the country in which we operate, should offer us a reliable court system. Now, the Dutch court system consists of 11 sub-districts and 4 districts. We have a layered court structure. That is generally the case in countries. You have lower and you have higher courts. All these details are not so relevant now from a business perspective. We are simply interested in the question, suppose we would have to go to court in a country. Can we then rely on the courts? Well, there are some sources which can help you in finding that out. Very briefly about the Dutch court system, it has a good reputation. Generally, when there are rankings, it scores very high. But, as said, when we talk about enforcing contracts, it doesn't score that high. So the picture is a bit mixed. A very reliable, professional, independent court system, but when it is about enforcing contracts, it may take some time and some cost, relatively more time, more cost than in some other jurisdictions. Why is this now in practice important? If the court system in a country is not reliable, you must avoid having to go to court if there is a future debate. This is specifically reasoned, of course, in a business-to-business setting. And then you might say, yeah, but is there then an alternative for going to court? Yes, there is. We have so-called out-of-court resolution methods, and one of them is arbitration. And arbitration is used as an alternative. Now, arbitration will be in the next slide. What you see here is a fairly recent development. Legal industries can generate money for an economy. London in the UK contributes 1 to 2% of the national income of the UK. London has a flourishing legal industry. We said a couple of minutes ago, common law, read English law, is more popular than civil law. Following from it, English courts are more popular than courts in civil law countries. But the Netherlands, we realized that there's money to be made by international trade courts. So we recently opened up a Netherlands commercial court. That court is specifically available to litigate in English in the Netherlands and is specifically targeting companies and offering them an international opportunity to have their international business disputes solved. That's the latest development, and this should of course contribute to the Dutch economy. If you cannot rely on a court like the one I previously showed you, you must start thinking about out-of-court dispute resolution. We have arbitration, we have mediation, and arbitration is used by companies as an alternative for going to court by including in their contracts that if they will run into a dispute in the future, they will submit it to arbitrators. And arbitration is simply a private court with privately selected judges to which the companies submit their dispute, and beforehand sign for the acceptance of the outcome. Very simply said, it's a privately created court. Companies can do that by themselves, but they can also make use of the facilities of Arbitration Institute. A famous one is in Paris, offered by the International Chamber of Commerce, but we also have one in the Netherlands. That's the Netherlands Arbitration Institute. Now, you can agree as parties to have the dispute decided upon by Dutch law or by English law. You're free to do so. And apart from the law which the arbitrators will apply, you also have rules for the procedure. The International Chamber of Commerce in Paris has procedural rules. The Netherlands Arbitration Institute also has its procedural rules. For the moment, the important message is there's a way to avoid going to court. Arbitration is the most favored one by international business. You can have it realized by agreeing upon it in your contracts. Then to the last S of services providers. I said to you, you're going to work a lot with third parties, market research agencies, web developers, but you're also going to work with law firms. Now, when you hire a third party, you are responsible for the result towards the company. You are spending money, you are doing that for a reason, and your boss will not accept that you fail because you committed yourself to doing something, to spending money, to spending resources, to spending your time with hiring, bringing into the company a third party. Now, in international business, it is fairly handy if you can operate internationally with one and the same law firm. If you can create a system of close cooperation with a law firm which is present in the whole of the EMEA, that will make things for you easier, and it will lead to a bigger commitment of the law firm because there's a bigger interest involved for them. Fortunately, the Netherlands can offer you an infrastructure of international law firms. Many of them are close by, here at the Zuidas, just around the corner. Some of them are in Rotterdam, but it's possible in general, if you are operating in the Netherlands, to cooperate with the law firm which also serves your company in other countries. Now, if you want to hire a law firm or a market research company, you need to know something of them. You should not simply open up the telephone book and call one. No, your selection of services providers is based on knowledge. Now, you need to be aware of names, just like you have good advertising agencies. You have good and international law firms. On the left hand side, you'll find the really big ones. In terms of revenue, they are mostly American or British law firms, for the reason that common law, English law, is so important in international business, for the reason that they have big home markets and that they have in the past followed their international clients into the markets in which their international clients expanded further. So you'll find them all around the world. In the Netherlands, the biggest law firms are these. This advocacy website publishes yearly a top 50 of law firms. And in general, you can say that the bigger the law firm is, the more expertise it has in-house. But that's of course a general statement, because it might well be that you are in a specific business which can only be served by a very small law firm who is completely specialized in that area of business. Now, there's another company, Acritas, which measures the corporate branch of law firms, and they have a ranking of the global elite law firms, and here you see some of the bigger names: Baker & McKenzie, which is around the corner here, DLA Piper, which is around the corner here, Clifford Chance, which is short by, Jones Day is short by, Allen and Overy is short by, and Hogan and Lovells is recently moved short by to the Amsterdam Zuidas. So these are the really big names in business. So if you want to play it safe, you can start with contacting one of these, but of course you should beforehand assess by looking at their website and maybe by looking at reviews whether they can offer you the specific business knowledge, legal business knowledge you require. Then just a note in between, not every country in the world has the same amount of lawyers per 100,000 inhabitants. We in the Netherlands are not having so many lawyers per 100,000 inhabitants. We're a bit in the middle group. Countries like Luxembourg, Cyprus and Greece, they have many lawyers per 100,000 inhabitants. What does it say? Not too much, but what it emphasizes is the general attitude towards litigation in the Netherlands, and that is avoiding it. We, the Dutch, generally try to avoid costs, and you know that going to court is generally costly, lawyers are expensive, and going to court may ruin a relationship. So, generally speaking, Dutch business will try to work towards out-of-court resolution of disputes. We are a compromise country, so if we have a dispute with another company, we will try together to get it solved. We call that by an amicable solution, and by this amicable solution, by negotiating together, we can avoid the high cost, the time investment, and the potential ruining of the relationship. So out-of-court solutions are popular in the Netherlands. If you would look at the website of the big law firms, you can find information on their level of internationalization, and when you are a truly international company, you see them present in all of the big markets in the world, and then you know, hey, they can support me properly anywhere in the world. Best companies also have business knowledge, because we're talking here about business, and you should be able already now, or at least at the end of the course, to understand what they mean with these legal areas. From a marketing perspective, this is of course weak, because you know that when you study marketing, you should speak to customers in the language they understand. And you could ask yourself, do you know, as a layman, as a lay businessman, what intellectual property is? Do you know what international commercial and trade encompasses? So here we see a law firm who communicates, expresses itself in legal terms, and those may be terms which customers not immediately fully understand. So from a marketing perspective, I would say some room for improvement. Not only do we have big law firms, but also smaller law firms have started internationalizing, knowing that some of their clients could be served with an international network. So even small law firms have started to create alliances, cooperation agreements with law firms in other parts of the world. Here we see a Dutch law firm which starts an alliance with a UK law firm, which is of course brilliant from the perspective of being able to offer knowledge of English law, the law of business, to their customers in Holland who want to do business and are confronted with the need to do so by involving English law. Now, another type of services provider I would like to mention to you are lobby consultancies, because we said sometimes lobbying might be necessary and we want to involve a lobby firm. Now, lobby firms are also organized, and we have an association of professionals in public affairs. These, if you don't know anything about lobbyists, offer you the opportunity, the starting point, to find a lobbyist which can best serve your interests. Well, this was quite a lot. We take a little break by realizing again that we are in this role of a manager who manages the EMEA, and we have a headquarters in the US. And this headquarters in the US has contacted you. Sales are going down because of the pandemic. And they sent you an email and they said, well, the wages, the salaries in the Netherlands are quite high. Can we try to get some people out? In business words, can we reduce the headcount in the Netherlands? And you are the EMEA manager, and you're being asked to draft a memo on the opportunities to terminate employment contracts. And then you realize that if you want to do that law, my son comes home, that law is a national thing, and that means that you are confronted with Dutch employment law. And we will see that Dutch employment law is part of a bigger area of law, social securities law. So I'm now talking half business, half law. You cannot answer the question, what are the opportunities to reduce the headcount and what would it cost, without some knowledge of law. And then you may think, yeah, but that is something I ask the legal department. You can try, but they might say, we're too busy. Try to find that out for yourself. Or you may think, well, I can contact the law firm, and then they send you a price proposal. Yeah, it's possible, but I need to discuss it with the accountant as well. So it would take me 8 hours and 4 hours for the accountant. So that's 12 hours, and we do it for €400 an hour. So for about €5,000 you have your memo. And then you think, okay, I'll not pronounce the word, but there goes your profit down with €5,000. If your boss would agree upon it. Yeah, and your boss will probably say, hey, that's a lot of money, can't you read around a bit by yourself? You did law at your university, why should we spend €5,000? Now, this is the situation, here you are, you have to dive into an area of law which is called employment law. For theoretical reasons, just the picture. The picture is, we speak about social law in the Dutch legal system. That encompasses, unites labor law, we will look into that, employment law, social security law. We will not look into law of civil servants, that used to be a specific area of law, but is now moving closely to individual employment rules. And we have the Works Council, which will pop up from time to time in this course. First we look into labor law, and then we will look into two types of employment contracts, individual employment contracts and collective labor agreements. Collective labor agreements, because that is very, very specific for the Netherlands. Now, if we look into the fundamentals of Dutch employment law, We see some things, and what we see is a definition of an employment agreement. It is an agreement, so it is a contract under which one of the parties, so you have two parties, you have an employee and you have an employer, but one of the parties, the employee, commits himself towards the other, the employer. And what does he commit himself to? To perform work for a period of time in the service of this other party in exchange for payment. So in this little article, and I will present them to you later, are the elements which create an employment contract. This one I skip, and now I go to this one, because what does it say? Both parties must behave reasonable and fair. And then your reaction is probably, what is that? Well, first of all, we should see that this is an open norm. And the open norm is applied in court on the circumstances. Suppose you come to work with a tattoo. Is that reasonable and fair from your side? Well, that depends on the circumstances, that will depend on where the tattoo is, that will depend on what the tattoo represents, and it will depend on the type of work you do. In some cases, a tattoo might be completely unacceptable, in other cases it might be completely acceptable. Another thing to realize is that employers are liable for the damage which an employee during the work inflicts on others. So employers have a liability for what employees do during their work. That's fundamentals. Now, I said to you I will introduce to you the elements which were in this law definition of employment contract. So what are the elements? The one element is subordination. Subordination means the employer can give instructions. John, can you please? Then you are supposed to do it, provided of course it's not unreasonable, and provided of course it is not illegal. An employment contract involves a payment that can be in money, but it may also be in kind, housing for example. It involves a certain time, you work during a certain duration, and you have to do the work personally. You cannot have your work, if you have an employment contract, done by somebody else without the consent of your employer. Now, employment contracts come in different types. A very simple distinction is between definite fixed term or indefinite term. Fixed term, for example, 6 months or 1 year, and indefinite term without an ending date. Now, at the beginning of this year, a new rule was introduced. Dutch employers pay a premium for unemployment benefits. That premium is related to the salary. It's a percentage of the salary with a maximum, but the percentage to be paid is linked to the type of contract. So if an employer has employed people on an indefinite term contract, the percentage is around 3%, but if he uses definite fixed term contracts, the percentage is almost 8%. There's about 5% difference in contribution by a premium which an employer must make to the funds which are used to pay people unemployment benefits. Why is this difference so big? Because the government saw it as a strategy to stimulate employers to reduce the number of definite term contracts and to start working more with indefinite term contracts. Yeah. Then we will look quickly in one of the following slides on the secondment agreement, de uitzendovereenkomst. And then we have open on-call contracts, in which people have a contract, but there is no fixed or limited number of hours in it. And there's also an opportunity to have a payroll contract, in which a person is on the payroll of a company, but actually performs the work in another company, and that another company pays a salary to the payroll company, and the payroll company pays to the person who is on their payroll. Now, an employment contract will contain, of course, all kinds of elements. Just browse through it, but what we see here is that employment contracts will also indicate what type of collective labor agreement applies, and the collective labor agreement will come in a few slides because the whole concept is so important for the Netherlands. And here now we will briefly look at this secondment agreement. This secondment agreement is an arrangement which involves three parties, and it's maybe a bit difficult to describe, and it's best, I think, visualized. In the secondment agreement we have a company, Randstad, een uitzendbureau. And this Randstad makes a temp available, puts a temp, a human being, available to a company. So the temp agency has an employment contract, mark this work, has an employment contract with the temp, but the temp works for the company which has a contract with the temp agency, and that's a so-called contract of instruction. Now, the company for whom the temp works is called the recipient, and the temp does not have an employment contract with the recipient. As said, the temp has an employment contract with the temp agency. Now, yes, they have an employment contract. Now that is the difficult situation of three parties, two types of contracts, and the recipient, which by law, that is in the previous slide, has the opportunity to include in the contract the opportunity to send the temp home without any longer being bound to the contract with the temp agency. So if the recipient comes to the conclusion that the temp is not performing satisfactorily, he will have a clause in the contract which allows him to send the temp back to the temp agency. And because the temp agency has an employment contract with the temp, the problem is for the temp agency and not for the contracting recipient. Difficult subject, and that is the termination of employment contracts. If you start writing this down in the memo to headquarters, it becomes incredibly confusing because there are quite some options, but all these options have consequences. And these consequences of the termination options, those legal consequences, involve, from a business perspective, financial risk. If we start with the employee can always leave. The only thing he should do is take into account the termination term, So he may have to say, I leave in a month or 2 months, but then he's free to go. The employer cannot simply end the contract by notification, by a simple letter. He can do so if he gets the consent of the employee. Another option is that he notifies, legally valid, because he gets permission from the UWV, the Employee Insurance Institute. Another option is that you come to a contract together, you agree on terminating, and you document the conditions in a termination contract. An employer, but also an employee, can go to court. An employee will generally not do that quickly, but an employer may go to court and ask the court to dissolve the employment contract. Another option for the employer, but also for the employee, is when something very, very serious happens, like theft or abuse or fighting or constant drunkenness, then there might be a justification which qualifies as urgent reason, and then the contract can be terminated by a simple notification. And then we have the system of a probationary period of maximally 2 months. In that time, in those 2 months, both parties can always terminate without having a reason to do so. This is a complicated system which in practice leads to some kind of a chess game, and this chess game results from the fact that financial interests are involved. A bit more about what we specifically said. We talked about the UWV, the Employee Insurance Institute. That can give permission to terminate by notification only if there are economic reasons or if somebody was ill for over 2 years. The court can dissolve, and there are a number of opportunities. What you see here are all kinds of reasons in the personal sphere of the employee, and if one of them is 100% evidenced by the employer, the court may come to the conclusion that the dissolution of the contract, the setting of the contract, is justified. And if one of them cannot be completely evidenced, the employer can try to evidence a combination. Some of the grounds are fulfilled almost completely, and that combination convinces the court that the setting aside of the contract is legally justified, and then the court may do it. Now, what is the legal risk? The legal risk is that the legal risk is that the method entitles an employee to a transition compensation. That transition compensation is linked to the UWV route. So if the UWV consents to termination, the employee is entitled to a transition compensation. That transition compensation is 1/3 of the monthly salary for every year he worked for the company. So 10 years is 10 times 1/3 of the monthly salary. The transition compensation is also linked to setting aside by the court, and the transition compensation is also linked to an employee that consents to the employer to terminate the employment contract by notification. Please read chapter 2 for the details, because the system is rather complicated. But you can say now to the headquarters writing that memo, these are the options and these are the potential costs, whereby if you terminate with mutual consent, parties are free to set an amount, but in practice the transition compensation is usually used as the threshold the benchmark for a compensation which an employer offers to an employee. Now, we talked about 40 redundancies. Maybe we can make use of a special facility for that. We have a law on collective redundancies. If you want to fire, dismiss at least 30, you can follow the procedure in that legislation. And what you should do is you should consult the UWV, the Employees Insurance Institute. You should consult the trade unions, and you should make an agreement with the trade unions on how you're going to dismiss and help the people and what you will offer them. That is what you have to write down in a social plan. And if the trade unions accept the social plan, the UWV will give you, generally speaking, permission to terminate the over 20 employment contracts. Here you see how it happens in the past. A company in the south wanted to reduce 1,500 workers. A social plan was created and the social plan was accepted, and the termination could take place. Here it is in Dutch, but it is about a social plan and negotiations of a company with the trade unions. The easiest way to terminate employment contracts is in bankruptcy. Yeah, but then you are bankrupt, of course. But in a bankruptcy, without having to pay any transition compensation, the receiver, the lawyer or accountant who manages the bankruptcy, can terminate without any permission being needed the employment contracts of the employees in the bankrupt company. Now, we are having an EMEA setting, so the rules might be completely different in other countries. There are some reports available on international dismissal regulation, which you can consult to draft your report for headquarters in the US. And finally, a few words about which is very typical for the Netherlands, our social security system. In life, all kinds of things can happen. You can become unemployed, you can become seriously ill, you might die still having young children, you might get healthcare costs which are so high that the normal insurance cannot bear them. And for all these risks of life, we have created a social security system of social security and healthcare cost, which is the biggest chunk of what the government spends from the income it generates from gas and taxes. And how is that social security system funded? It is funded by taxes and premiums, which are levied by salary tax, corporate tax, premiums paid by people, and premiums paid by employers. So this is the spendings and the fundings of the Dutch social security system, which consists of three parts: national insurances for everybody, insurances only for employees, and welfare provisions which are available to those in need. The relevance of it is that employer, for the bigger part, and to some extent employees, pay premiums for the so-called employee insurances, which entitle employees and not freelancers to certain provisions. Now, in between this, Dutch law has a special rule. If an employee gets ill and he cannot work, the employer must continue to pay the salary for another 2 years, and it is at least 70% of that salary. That is completely different in other countries of the world, but that is a system which the Netherlands has, which by employers is not appreciated and which prevents them from hiring people on an indefinite term contract, because they know that if the people get ill, they have to continue to pay the salary for 2 years. Now, as said, those employee insurances are not available for freelancers. We are now in COVID times. A lot of freelancers are simply having their contracts terminated because they don't have employment contracts, so termination is easy. They are not entitled to any unemployment benefits based on the Unemployment Act, and if they get ill seriously and become incapable to work, they are not entitled to any benefits based on the Dutch work according to the Labour Capacity Act. So they basically get nothing. The only thing which maybe is available to you is a benefit from the Participation Act, but that benefit will normally only be allowed to you if your assets do not exceed an amount of around 6,000 euro. So the freelancer which is now without work will not get unemployment benefit, will not get any benefit from the Participation Act. So he must await the moment he falls into complete poverty before he can entitle himself to a benefit from the Participation Act. But of course you will have heard in the news that at the moment there's a whole system of benefits available to freelancers and companies who have their profits or income reduced due to the COVID crisis. Now, those are all arrangements which cost a fortune and are very detailed. Plans were developed to create the opportunity for disability insurance for freelancers, but that would cost them a substantial amount of money. It is estimated to be around 85 to 150 a month. Now this is we're going towards the end. This is this social security picture. It involves municipalities, the tax authorities, the UWV, care offices and a social insurance bank. They are all involved in distributing the benefits to which people are entitled. We go towards we bring some things together, information, we integrate, and we give you, just like the previous lecture, a self-assessment format. Governments have websites, the Dutch government also has it, and even in English, where you can find information about the regulatory environment. We know from the first lecture that there are brilliant reports available from consultancy companies. This is from PricewaterhouseCoopers, now called PwC. And when you look at the structure of the report, you see what we are looking into. When they present a picture of the business environment, they look into legal system, they look into employment law, and they look into taxation. The picture which they give us of the Netherlands is incredibly positive. You can read it here, but the Dutch have always learned to be modest, so I will not explicitly read them out, but leave them for you to read. But actually it's very good. Now for you, because you are studying business and you will constantly hear in your studies about the SWOT. This is a SWOT, at least a part of it, the opportunities and threats of the Dutch regulatory environment. Have a look at it and try to understand it. And here you have the nasty questions for you from head office, your self-assessment format. Give it a try to formulate an answer to these assessment questions. I hope you can do so. It was a long lecture, also because I had some hiccups in the recording. I had to stop a couple of times, but we did a lot. Read chapter 2, and I thank you for your patience to sit this lecture, and I hope to see you in the tutorial. Now it's time for a Dutch coffee with a Dutch cake. See you in the tutorial and hopefully in the next lecture, which will be about the European Union. Thanks a lot.